Welcome once again to Lehto's Law. Here's Steve Lehto.
Got a great story passed along to me by Jason, and it's out of Arizona. And we talked before about why police pull you over, what right they have to pull you over, and so on. And this one shows you the lengths they will go to make up something. And a new American hero, I guess, is James Flynn. Case is called James Flynn versus, and it lists a whole bunch of people, including the state of Arizona. And this is from the Arizona Court of Appeals. And what happened was that Mr. Flynn got arrested for something. He got pulled over in traffic, got arrested, went to trial, and at the lowest court he was in front of, they threw the evidence out for reasons we'll discuss. The next court up reinstated it. He took that to this court, and this court then throws it back out again. But the facts are what will blow your mind. James Flynn petitions for special action relief from the Superior Court's order reversing the municipal court's decision to suppress evidence obtained following a traffic stop. That's how they explain what I just explained to you. For the following reasons, we hear the case and grant relief. In early 2018, Flynn was charged in the city of Mesa Municipal Court with 4 counts of driving under the influence, or DUI. Flynn moved to suppress evidence obtained from the traffic stop, alleging the arresting officer had no reasonable suspicion to initiate the stop. He says the cop had no reason to pull me over. Okay? If the police officer has no reason to pull him over, then everything that flows therefrom should get thrown out the window. At a June 2018 evidentiary hearing, the officer testified that, and now he's going to explain why he pulled Mr. Flynn over. While on patrol for a DUI task force, around 9:30 p.m., he observed Flynn exiting a strip mall parking lot near Dobson and Guadalupe Roads in Mesa. So he sees him. The strip mall contained several restaurants that were open at the time, but the officer knew there was a hole in a fence on the opposite side of the complex that separated the strip mall parking lot from an adjacent bar. He followed Flynn for approximately 2 miles. So he saw him leaving from a parking lot where you could, if you wanted to climb through a hole in the fence, get to another parking lot. He did not see anybody climb through the hole in the fence, but he knew the hole was there. But no one's blaming the hole, and the hole's not on trial. But the hole is there and it's part of the story. He followed Flynn for 2 miles. During this time, the officer estimated that Flynn's speed was between 28 and 35 miles per hour. This is important, between 28 and 35, because the speed limit was 45. In the course of following Flynn, the officer observed no traffic violations or any clues of impairment. The man was driving down the road below the stated speed limit, was not doing anything unusual or illegal, except that perhaps he's driving below the speed limit, when we all know that sometimes there are times on certain roads where people drive above the speed limit. But this man was driving below the speed limit and breaking no laws. That officer testified he initiated the stop solely because Flynn left the vicinity of a bar and then traveled at a speed that varied but remained below the speed limit. I got news for you. Unless your cruise control's on, your speed will vary from time to time. The officer did not remember how many times Flynn's speed varied. He did not have any clear recollection of where the fluctuations occurred, or whether Flynn had been required to stop or slow down for any of the 7 light-controlled intersections the pair encountered. So it may be he slowed down for intersections and then sped up again. That would be your speed varying. Nor was he able to testify as to how frequent or great a speed variance would need to be to qualify as a clue of impairment. In other words, is he stomping on his brakes for no reason and then accelerating for no reason? No evidence of that. After taking the matter under advisement, the municipal court determined the state had not met its burden of proving the officer had a valid, reasonable suspicion to initiate the traffic stop and granted Flynn's motion to suppress. On appeal, the Superior Court reversed. Sure, why not? Flynn now petitions the court for special action relief from the Superior Court's final judgment, and they accept the appeal for reasons, which I won't go into now because it's half a paragraph of gibberish. Flynn argues the Superior Court decision to reverse the municipal court's suppression order is error, and they talk about the Fourth Amendment protecting against unreasonable searches and seizures. A law enforcement stop of a vehicle constitutes a seizure and must be justified by some objective manifestation that the person stopped is or is about to be engaged in criminal activity, citing State v. Gutierrez, 2016, quoting State v. Rich Creek, Arizona, 1997, Hunches, intuition, and unparticularized suspicion are not enough. The totality of the circumstances must provide a particularized and objective basis for suspecting the particular person has violated the law. Again, Gonzalez Gutierrez, quoting United States versus Cortez, 1981. So you can't say it was a hunch. I had an inkling. I got the heebie-jeebies. No, you have to have an actual particularized and objective basis. And a particularized and objective basis is different than a hunch. It says here we might typically afford deference to a trained law enforcement officer's ability to distinguish between innocent and suspicious actions, but such deference is not appropriate here. As the municipal court's order makes clear, the officer did not provide a factual basis for a suspicion that Flynn was impaired. The court specifically found the officer had no objective reason to believe Flynn was not conducting legitimate business within the strip mall. The officer could not remember when or how often Flynn's speed varied. The officer could not articulate any standard upon which to conclude a speed variance resulted from impairment. These findings are supported by the record and indicate the municipal court did not find the officer's assessment credible. Moreover, we agree with other courts that have recognized that driving below the speed limit does not by itself furnish reasonable suspicion. And that's important. If a police officer could pull you over for driving below the speed limit, and he can ticket you for driving above it, that means that theoretically, you get in a road with a speed limit's 45 miles an hour, you better do 45 miles an hour the instant the light goes green, and stop doing it at a red light, but maintain exactly 45 in between, because a police officer can pull you over for either going above it, speeding, or going below it, acting suspicious. I'm being partially facetious here, but I think you see the point. That if they say this is the limit at which you have to stop accelerating or going faster, oh God, the physics people in the audience are going to go nuts on that one. You can drive in this range from 0 to 45. Okay? Driving within the range then is not illegal. In fact, that's expressly what's allowed by the speed limit sign. When considering all the above factors together, viewing the evidence in light most favorable to the municipal court's order granting the motion to suppress, we cannot say the municipal court abused its discretion. The Superior Court erred when it failed to give the municipal court's decision proper deference, second-guessed the municipal court's assessment of witness credibility, and it reweighed the evidence, which it's not supposed to do. Accordingly, we accept jurisdiction and grant relief. The Superior Court erred in substituting its judgment for that of the municipal court. Accordingly, the decision of the Superior Court is reversed. The case is remanded to the municipal court for proceedings consistent with its decision, which means that the traffic stop has been deemed unjust. Everything that flowed therefrom will not be allowed into court, and I suspect that James William Flynn will now leave a free and untarnished man, other than he had to go through this. But remember, this all started in early 2018, and here we are at the end of 2019, and this is just now getting wrapped up. So it's a waste of time to be tied up in court like that, but at least he won in the end. And yes, the idea that a police officer can say, you're breaking no laws, but I find that suspicious, is a problem. And the Arizona Court of Appeals appears to agree. I suppose that the state could take that up to the Arizona Supreme Court. Good luck with that. But I will tell you one thing. When I was in law school taking constitutional law, we talked about the Fourth Amendment quite a bit. And it was in that class that we read a series of cases involving searches of people who got off airplanes back in the early days of the war on drugs. And you do basic math and figure out that a lot of the cocaine coming into America was coming in on airplanes from Central and South America. And so the DEA agents would watch for people coming off the plane who looked suspicious. And they would search them and find, suitcases full of cocaine. And so they'd often, at the hearings on this, ask the DEA agents, why did you think that person looked suspicious? And at first they'd say, oh, well, the guy came off the plane last. And so people coming off the plane last are doing so hoping that they can blend into a crowd easier and that somebody else will have caught our attention. They're coming off the plane last specifically for that purpose. And then, of course, later on, they'd grab somebody who got off the plane first who looked suspicious. And they go, well, they got off the plane first because they were trying to get out of there in a hurry. And that made them look suspicious to us. And then, of course, I don't need to tell you this, but I will. They would grab people from the middle of the plane or from the middle of the people coming off the plane. And they'd say, well, they knew that people in the front and people in the back looked suspicious, so they're coming off in the middle. And there are actually cases where they point out that the DEA agents, the people testifying for the people, that's correct actually, would say all of the above. They'd say if you came off here, you're suspicious. You came off here, you're suspicious. You came out. Everyone is suspicious at that point, okay? And if everyone is suspicious, then there's nothing to do. You can't say we're going to pull over everyone because they look suspicious, because that's not how it works. There's got to be something that they can point to and say, that right there led me to believe. So if we'd seen the guy leave the bar, stumbling out of the bar, get in his car, and then drive erratically through the parking lot, and then weaving down the road and braking for no reason, and then accelerating for no reason, and then driving on the wrong side of the road, you'd say, oh, all of these things would tend to indicate there's something impaired about his driving, which might be linked to the bar we saw him stumbling out of, okay? And that would hold up in court. But when you say, I saw a guy pull out of a parking lot with a bunch of stores, one or two of which sell alcohol, and then he drove perfectly legally down the road, I decided to pull him over because he was acting too legally? And this is the kind of thing where you go, this is insanity, okay? Except that of the 3 courts that heard this, one of the courts actually bought it and actually overruled the other court before they got overruled. So there you go. The case is James William Flynn versus a whole bunch of people. And that's how it goes. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thanks for watching Lehto's Law.